The landscape of firearm ownership in the United States is perpetually shifting, not always through the passage of new laws by Congress, but often through the interpretation and rulemaking of the very agencies tasked with enforcing them. For the ordinary citizen, staying informed about these regulatory undercurrents is not a matter of political punditry, but a practical necessity for remaining on the right side of the law. Understanding the authority and the limits of agencies like the Bureau of Alcohol, Tobacco, Firearms, and Explosives is crucial because their regulatory decisions directly impact the daily legality of buying, selling, and possessing firearms. When the ATF signals a new area of interest or announces a shift in enforcement priority, it can fundamentally alter the legal landscape for millions of law-abiding gun owners, often with little public fanfare outside of specialized legal and advocacy circles. This makes it essential to cut through the heated rhetoric and examine these developments with a clear, legally focused lens to understand what is actually changing, what is simply a clarification of existing law, and where the constitutional boundaries lie. With that in mind, consider this. If the ATF were to announce it has an interest in limiting the sale of firearms through unlicensed private transactions, what legal authority do they actually possess to enforce such a limit? And where does the constitutional right to keep and bear arms intersect with the government's interest in regulating commerce? I encourage you to share your thoughts on this question in the comments below, as it gets to the very heart of the tension between federal regulatory power and individual rights. To properly understand the current news cycle surrounding the ATF's regulatory interests, we have to start with the foundational statutes that define their existence. The ATF operates within a legal framework established by Congress, primarily the National Firearms Act of 1934 and the Gun Control Act of 1968, as amended over the decades. The NFA was the first major piece of federal firearms legislation, imposing a tax on the making and transfer of certain weapons like machine guns, short-barreled rifles, and suppressors, and requiring their registration. This was a regulatory approach using Congress's taxing power, not a direct prohibition. The GCA, on the other hand, established the modern system of federal firearms licensing, prohibiting interstate firearm transfers between private individuals and creating categories of people who are barred from gun ownership, such as convicted felons and those adjudicated as mentally defective. These statutes are the bedrock. The ATF cannot create new criminal laws, but it can issue regulations and rulings that interpret and enforce the laws Congress has already passed. The current controversy often centers on the definition of who is engaged in the business of dealing in firearms. This is a critical distinction because anyone engaged in the business of dealing in firearms must obtain a federal firearms license and run background checks on purchasers. A private individual, however, can occasionally sell a firearm from their personal collection without a license, a transaction commonly referred to as a private sale. The ATF's interest in this area stems from a concern that individuals are using the private collection loophole to essentially run a gun business without a license, thereby avoiding background checks and record-keeping requirements. In April of 2024, the ATF published a final rule aimed at clarifying this very point, defining what it means to be engaged in the business as a dealer. The rule attempts to provide clearer criteria for when a person's conduct crosses the line from hobbyist or collector to unlicensed dealer. This has been met with immediate legal challenges, with state attorneys general arguing that the rule goes beyond the authority granted to the ATF by Congress and infringes upon the Second Amendment rights of law-abiding citizens who simply wish to sell a firearm from their personal collection. This brings us to the constitutional backdrop, which has been anything but static in recent years. The Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin in 2022 fundamentally altered the legal test for evaluating Second Amendment challenges. Prior to Bruin, lower courts often used a two-step approach that balanced the historical tradition of regulation against governmental interests like public safety. Bruin rejected that interest-balancing approach, holding that, when the plain text of the Second Amendment covers an individual's conduct, the government must affirmatively prove that the regulation is consistent with the nation's historical tradition of firearm regulation. This means that for any new ATF rule, such as the one clarifying the definition of a dealer, the government must be prepared to defend it by pointing to analogous regulations that existed at the time of the founding or in the early republic. The burden is no longer on the citizen to prove their right has been violated, but on the government to prove their restriction is historically rooted. This historical test is complex and highly fact-specific. For instance, in the context of prohibiting drug users from possessing firearms under 18 U.S.C. Paragraph 922 G3, the government is currently arguing before the Supreme Court in United States v. Khomeini that such restrictions are analogous to founding-era laws that disarmed drunkards or individuals who were considered to pose a danger to the peace. The respondent in that case argues that the historical laws targeted those who were actively intoxicated and posing a threat, not merely those who used substances in the past, highlighting the intense debate over how closely a modern law must mirror a historical one to pass constitutional muster. This case, and others like it, will directly shape how far the ATF can go in regulating who can buy and sell firearms. The distinction between federal and state law adds another layer of complexity. While the ATF enforces federal law, state laws regarding firearm sales, ownership, and carry vary dramatically. For example, some states have essentially adopted the federal standard for dealer licensing, while others have enacted their own, more stringent requirements for private sales, often requiring a background check through a licensed dealer, even for transactions between two private individuals. A citizen's legal responsibilities are therefore a patchwork of federal mandates and state-specific requirements. You can be in full compliance with ATF regulations but still violate your state's laws, and vice versa. This is particularly evident in the realm of carry laws. While the ATF does not issue concealed carry permits, the Federal Firearm Owners Protection Act does provide some protections for individuals transporting firearms through states where they may not be licensed to carry. Yet, as the situation in New York demonstrates, some states have historically made it nearly impossible for non-residents to obtain a license, effectively barring them from carrying within state lines, a practice now being challenged under the Bruin framework. Understanding whether your state is a permitless carry state, a shall-issue state, or a may-issue state is just as important as understanding federal law. Ownership laws also extend beyond the simple act of purchase. There is a growing trend at the state level to impose specific storage requirements on gun owners. For instance, a bill introduced in the Kentucky legislature, Senate Bill 105, sought to require that firearms be stored in a safe storage depository or rendered incapable of being fired with a locking device. While such a bill may not directly stem from ATF action, it represents a parallel track of regulation that firearm owners must navigate. The bill also proposed a requirement to report lost or stolen firearms to law enforcement, a type of mandate that is becoming more common and carries its own criminal penalties for non-compliance. These state-level initiatives often fill the gaps that federal law does not cover, creating a complex web of responsibilities for the owner. The permit systems themselves, where they exist, are primarily a creature of state law, but they intersect with federal requirements in significant ways. For example, a state-issued concealed carry permit can sometimes serve as a proxy for the federal background check required by the Gun Control Act when purchasing a firearm from a licensed dealer. This is because the permitting process involved its own background check, satisfying the requirement that the buyer is not a prohibited person. However, the ATF has the authority to determine which state permits are acceptable for this purpose, and this list can change over time, directly impacting the purchasing experience for permit holders in different states. This interplay shows how federal agency decisions can have a direct and practical impact on what might otherwise seem like a purely state-level process. Beyond the point of sale, the legal responsibilities of a gun owner extend to the actual use of a firearm for self-defense. While the ATF is not involved in prosecuting justified self-defense cases, the legal principles governing the use of force are critical knowledge. The vast majority of states follow either a stand-your-ground doctrine or a duty-to-retreat framework. In stand-your-ground states, an individual has no duty to retreat from any place they have a lawful right to be and may use deadly force if they reasonably believe it is necessary to prevent death or great bodily harm. In duty-to-retreat states, the individual must attempt to avoid the confrontation by retreating, if it is safe to do so, before resorting to deadly force, with the common exception being within one's own home, under the Castle Doctrine. Misunderstanding these doctrines can lead to severe legal consequences, including criminal charges, even in a situation where the individual felt genuinely threatened. The law requires that the fear be objectively reasonable and that the force used be proportionate to the threat. The decision to use a firearm is irrevocable, and the aftermath will be scrutinized by law enforcement and the courts based on these legal standards, not simply on the subjective fear of the shooter. A common misunderstanding among many firearm owners is the scope of protection offered by the Second Amendment in relation to property crimes. There is a persistent misconception that the use of deadly force is justified to protect personal property, such as a car or other valuables. However, as a general rule, deadly force is only justifiable to prevent death or serious bodily injury to oneself or another person. While specific state laws vary, using a firearm against someone who is, for example, stealing a car from a driveway, but poses no physical threat to the owner, is highly unlikely to be considered justified and would almost certainly lead to criminal prosecution. The value of property, no matter how great, does not legally equate to the value of a human life in the eyes of the law. This is a fundamental principle that separates the lawful use of a firearm for self-preservation from its unlawful use as an instrument of vengeance or property defense. Another area of significant legal evolution is the question of who exactly is protected by the Second Amendment. While the Supreme Court in Heller and Bruin referred to law-abiding, responsible citizens, lower courts are grappling with what that phrase means for the doctrinal analysis. Some state courts, like the Iowa Supreme Court in State v. Woods, have begun to apply what some legal scholars call Bruin Step Zero, a threshold inquiry into whether a person qualifies as law-abiding before they can even invoke Second Amendment protection. In Woods, the court suggested that a defendant found in possession of a small amount of marijuana was not a law-abiding citizen and therefore fell outside the protection of the Second Amendment entirely. This approach has been criticized by other justices on the same court, who argue that it creates an extra-textual hurdle not mandated by the Supreme Court, and that the historical inquiry should focus on whether the person's conduct places them within a traditional category of individuals who could be disarmed, such as those deemed dangerous. This debate at the state level foreshadows issues the U.S. Supreme Court may eventually need to clarify, as it directly impacts who can be prosecuted for simple gun possession. The regulatory landscape is also influenced by the ongoing evolution of the ATF itself and the political appointments that guide its priorities. Recent reports indicate that the Justice Department is actively considering rolling back certain gun regulations, potentially easing restrictions on private sales, and revising the forms required for gun purchases. These potential changes include altering the ATF Form 4473 and reconsidering which firearms can be imported, signaling a shift in enforcement and interpretation that could have wide-ranging effects. The creation of a dedicated Second Amendment unit within the Justice Department's Civil Rights Division further underscores the heightened focus on these issues at the federal level, as this unit is tasked with litigating cases to expand gun rights, such as challenging assault weapon bans. This demonstrates that the political and legal battles over the Second Amendment are being fought not just in the courts, but within the administrative state itself, as each administration uses the levers of executive power to shape policy. For the citizen navigating this complex environment, practical legal guidance must begin with a simple premise. Ignorance of the law is not a defense. It is the responsibility of the gun owner to understand not only the federal statutes and ATF regulations, but also the specific laws of their state and local jurisdiction. This includes knowing the legal definitions of self-defense, the requirements for lawful storage, the rules for transporting firearms, and the precise boundaries of what constitutes being engaged in the business of selling firearms. If an individual sells multiple firearms in a short period, or buys firearms with the explicit intent to resell them at a profit, they may be crossing the line into dealing without a license, even if they consider themselves a hobbyist. The new ATF rule aims to provide more concrete examples of this line, but it ultimately places the burden on the individual to ensure their conduct falls within the bounds of occasional, personal transactions. The real-world implications of these legal nuances are profound. A person who unknowingly sells a firearm to a neighbor in a state that requires all transfers to go through a licensed dealer has committed a criminal offense, regardless of their intent. A person who uses a firearm to defend their property in a jurisdiction that strictly limits self-defense to threats against persons, not property, faces the real possibility of conviction for aggravated assault or even murder. The law does not operate on feelings or good intentions. It operates on statutes, case law, and regulatory definitions. This is why ongoing education is not merely a recommendation, but a core component of responsible gun ownership. Relying on information from a decade ago or from a friend can be dangerously outdated. Moreover, the legal landscape is not static. The Supreme Court's decision in Rahimi, which upheld the federal law disarming individuals subject to domestic violence restraining orders, clarified that the Second Amendment is not a limitless right and that dangerous individuals can be disarmed. Yet, even in that ruling, the court applied the Bruin historical test, demonstrating that the framework is here to stay. The ongoing cases regarding drug users and firearm possession, bans on specific rifle platforms, and non-resident carry permits will continue to refine the boundaries of the right. For instance, the debate over whether so-called assault weapons like the AR-15 are protected by the Second Amendment is likely to return to the Supreme Court. The central question in such a case would be whether the plain text of the amendment covers all bearable arms, leaving the common use test to the historical analysis, or whether common use itself is a threshold question at the textual stage. The answer to that question will determine the fate of numerous state-level bans. In light of these complexities, the responsible gun owner must adopt a proactive approach to legal compliance. This means periodically reviewing the ATF's published rulings and guidance, checking for updates in state law through official legislative websites, and seeking training from qualified instructors who emphasize legal updates as much as marksmanship. It also means understanding the resources available, such as the process for appealing a NX denial, or the requirements for lawfully transferring NFA items like suppressors, which involve fingerprint cards, photographs, and potentially months of waiting for ATF approval, although electronic filing has dramatically reduced wait times in some cases. Engaging with the legal process, even in the administrative act of purchasing a firearm, requires attention to detail and a willingness to follow procedures precisely. It is also important to recognize the role of state initiatives in shaping the future of gun policy. California, for example, has passed legislation requiring the Department of Justice to mail informational letters to all new firearm purchasers, detailing safe storage laws, the risks of gun ownership, and resources for domestic violence and suicide prevention. This represents a different regulatory approach, one of mandated education rather than direct prohibition. While some may view this as an overreach, it is a legally enacted requirement that purchasers must be aware of. Similarly, the requirement to report lost or stolen firearms, as proposed in Kentucky, shifts the responsibility of notification from law enforcement discovering the loss to the owner proactively reporting it, a change with its own set of penalties for non-compliance. These state-level developments are just as important as federal ones. Ultimately, the information presented here is not intended to alarm, but to empower. A well-informed citizen is better equipped to exercise their rights responsibly and within the bounds of the law. The ATF's stated interest in limiting certain types of sales, or in more strictly defining who is a dealer, is part of an ongoing national conversation about the balance between public safety and individual liberty. That conversation is shaped by laws, court rulings, and regulatory actions that are complex and often counterintuitive. By approaching these topics with a calm, logical, and legally grounded perspective, we can move beyond the sensationalism and focus on the practical realities of compliance and rights preservation. The Second Amendment protects a fundamental right, but like all rights, its exercise is subject to regulation that, under current jurisprudence, must be consistent with the historical traditions of the nation. Understanding that tradition and how it applies today is the lifelong work of the responsible citizen.